Hello and welcome. This is Grant Hughes of Grant Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching. What's going on, freaks? Well, I did come back again because I had this Judge Gull, like a PDF file from the courts. I got it earlier, but I was doing something else. Alright, so we're going to go over this. Judge Gull's response to having her removed as a judge, etc. Right? Remember that? They requested her recusing herself. Well, she didn't do it. So I heard this is a pretty sweet document here, so we'll have to check it out. But here's the goal for you guys here. So we didn't make the goal on the last show, and all we have to do is $60 on this small little show here. That's it, man. And we'll get right there. It'll be the easiest thing you've ever seen in your life. Alright. There we go. Just trying to make things happen, you know? Trying to make things happen. Alright, so the court has reviewed the defense's second verified motion to disqualify judge and requests for findings of facts and conclusions of law upon denial of the request. If this court denies this request filed May 17, 2024. And I think that was when they had when they said you need to have all of it documented and everything. As Trial Rule 52 is not applicable in criminal cases, the defendant requesting for findings of fact and conclusions of law is denied. Meaning, I don't have to give you the conclusions, I don't have to do anything. The court, however, will address each of defendant's allegations in this order. Oh man, I think this is going to be good. Defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14th, 2023 regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. So let's see. Defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14th, 2023 regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness' refusal to cooperate and be transported to the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. Let's see. Defendant claims the court engaged in ex parte communication with the Carroll County Sheriff regarding defendant's housing, transportation, safety during jury selection and trial May 13th through 31st, 2024. These communications were administrative in nature and did not address any substantive, that word is one of the hardest words for me to say for some reason, issues. The communications were directed to where the defendant would be housed during the trial and who would be conducting transportation. The court did not notify counsel where defendant would be housed during the trial, as he is still under the safekeeping order. The court did not notify the counsel where defendant would be housed during the trial, as he is still under safekeeping order, in an email, but did not inform counsel of the communication, as nothing of value was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of his second verified motion to disqualify. Let's see. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to disqualify. Right. Remember, she had to go through all of this stuff before she continued on any other work. Thanks, Karen Andrews. Hey, we're only 58 more to go, you guys. Only 58 more to go. Let's see if the small little freak community that showed up for this last-minute live stream can get us to at least a goal. We haven't hit the goal in, I don't know, 2 or 3 nights. The court is always, I guess, yesterday we did at the end. Yeah. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28, 2024. Counsel claimed that the defense claimed that the court has disparaged them and ruled on defense pleadings without hearings. The court's comments about counsel's performance were documented in the court order in April 30th, 2024, regarding their handling of discovery materials. If pleadings on their face are not supported by law or admissible evidence, judicial economy does not require a hearing. If pleadings on their face are not supported by law or admissible evidence, judicial economy does not require a hearing. Right, so why would you need to have a hearing in that case? Allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18, 2024 hearing. The court was notified on May 20, 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9, 2024 regarding ex parte communication received by the court from Gary I guess this is Fig Sauls. So right here it says, let's see. Let's read what it says. The court was notified on May 20th, 2024, that's just 14 days ago, of an inquiry of the Indiana State Police to the court reporter via email on May 9th, 2024 regarding Fig Sauls, which was probably provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. Defendant blames the court for ex parte pleadings which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential markings make them available to the state but not the public. Counsel's staff contacted this court staff and were advised that the statewide Odyssey case management system, so it says the court staff and were advised that the statewide Odyssey case management system, not Docs Pop as alleged in the pleading, has a distinct process for filing pleadings ex parte as opposed to confidential. All right. Where was I? The court did email defense counsel a tutorial paper authored by JTAC explaining the process. Since that communication, defense counsel have no issue with their staff properly filing ex parte pleadings. Accusations of violating rules on access to court records have been completely explained and dealt with, including the Indiana Supreme Court in the first writ of mandamus filed by defendant. Counsel claim their motions are treated differently than those motions filed by the state. The court has set hearings on pending motions which have now been continued due to the filing of the motion to disqualify. When defendant files pleadings, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's responses. Once the issues are closed, if a hearing is required, one will be set. So are we not going to try to reach that little small goal that we got, you guys? I just want to try to get to the goal. Just one. I mean, it just feels crazy how difficult it is these days. It's tiny. And if not, just let me know. Is it just say no in there, and then I'll go ahead and just finish off this stuff, because it's a weird feeling. Once the issues are closed, if a hearing is required, one will be set. Defendant asserts, so a counsel, the defense team, asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6, 2024, defendant filed a motion for speedy trial. The court granted that motion on March 7, 2024, and set the case for a speedy trial May 13th through the 31st. And remember, I had all the tickets, hotel, everything booked up. On April 30th, 2024, defendant filed a motion for a pre-trial hearing, which the court set for a hearing on May 7th, 2024. At no time prior to the May 7th, 2024 hearing did defendant advise the court that 3 weeks for a trial was inadequate. At no time prior to May 7th, 2024 did defendant indicate a belief that 3 additional weeks could be added to trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. So let's see. At no time prior to May 7th did defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. While the court agrees a continuance of the trial is harmful to the defendant and the state, it could have been avoided had counsel communicated prior to May 7, 2024. Counsel they notified the court on an order October 4, 2023, that they would need 2 weeks to present a defense. But the court has no record of that communication, nor any recall of such communication. Counsel's assertion that between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer, is irrational and unreasonable. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. Thanks, Paulette Leonard. Let's see. The court is required to guarantee sufficient time on the calendar and sufficient notice. So what does that say up here again? Let me see. With a combined 70 years of experience, not one time have they been told. So counsel's assertion that between all the defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer, is irrational and unreasonable. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. The court is not required to guarantee equal time for both the defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors as the parties to present their case, however long it takes. Right. Had counsel notified the court within days receiving the March 7, 2024 court order setting the case for a speedy trial, May 13th to 31st, 2024, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th through June 14th. The trial is now set for October 14th through November 15th, 2024, as requested by the defendant. That's crazy. Hey, thanks, Lisa Valenzuela. Counsel accused the court of engaging in extrajudicial activity. Counsel is correct that on July 9th, 2023, the court commented on a Facebook post. Let me just see this. So let's look at that. What does this say? I want to read what it said up here about the Gary thing. I mean, what were they? I don't even know what it was said. It just kind of. Oh, maybe that's what that was going to be about. Let's see. The court was notified on May 20th. Is there one before? That's only time. Okay. Received by the court from Fig Solve, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. Yeah, I don't know, man. It's so ridiculous. It'd be the same as if I was being looked at. I mean, he does exactly the same stuff that I do. You just communicate with people, and it's insane, man. Okay, counsel accused the court of engaging in extrajudicial activity. Counsel is correct that on July 9th, 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. How dare you, Judge Gull? The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament. If counsel's allegations in this part of their motion are well-founded regarding a potential witness' alleged social media activities and are presented to the court for ruling, the court will rule accordingly. Concerns about anticipatory rulings are not reasonable. The defense team asserts the court has denied reasonable requests for finding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. Well, I mean, the defendant's making bank on, these fundraising sites. I mean, what has he got, $40,000 at this point? This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000 for investigative services from June 4th, 2023 through October 16th, 2023 was in fact returned to counsel as no documentation was provided for service. They just sent a bill like, hey, you owe us $26,000. Good night now. No documentation was submitted until quite recently. With that proper support and documentation, the court authorized that invoice for payment on May 17, 2024. Defendant complains that public confidence in this case has eroded. I see it has in these Facebook groups, but the greater people out there have absolutely no, that doesn't bother them at all. There's nothing. It's just the wacko YouTubers, the 709 people that Zozo just mentioned. Crazy, absolutely nut jobs that are out there on Facebook. Unbelievable. Embarrassing, really. They want to free a killer. That's not true, Gray. We just want to make sure he has a fair trial. Let me ask you something. Would any of you have donated money to what's her name? Casey Anthony? You know, because let's say she didn't have quite enough money and everything. Would anybody have sent a nickel into Casey Anthony to try to get her, give her a fair trial, or Scott Peterson or somebody? No, and the reason is because they know that these people did it, right? In this case, they believe the people did it. Now, in this case, they always try to tell you they just want a fair trial. The truth is, they believe Richard Allen is innocent, and that's the only way you would ever donate to anybody. If you thought for a second even that he could be guilty, you wouldn't do that, right? Does everybody agree with that? I mean, it's just the way human nature is, man. It's common sense. Nobody, those 709 people right there, all believe Odinist did this and Richard Allen is being framed. And it's a cover-up by the Indiana State Police. Hey, thank you, 655. All right, man. Hey, look at that. We're only 43 short now of making the nighttime goal. Let's see. Defendant complains that public confidence in this case has eroded. As counsel should know, criminal cases are tried in a court of law, not in the court of public opinion. An independent judiciary requires that judges decide cases according to the law and facts without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public criticizing court both. See, this is disingenuous right here. Like the public confidence. What you're saying is based off of all of the crap of your Odinist BS that you've put out there, you've created confusion, and confidence is waning in. See, you got these people out there that claim that, oh man, all around the country everybody is thinking, oh wow, yeah, on YouTube. Like your Facebook buddies. There's a guy that lives over here. They're in a Facebook group. Wow, there's people out in Oregon that think, it's like, what difference does it make? The greater public isn't following all the wacky drama that's going on here. Yeah. The court continues to receive ex parte communications from the public criticizing the court. I actually sent one in one time saying, hey, keep your head up. You're doing a good job. Just an email. That wasn't me. An independent judiciary requires that judges decide cases according to law and facts without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public criticizing the court both personally and professionally and threatening court with bodily harm and injury. The court continues... Man, who the hell would do that, man? Jesus. The court continues to provide these communications to the parties. The court is not interested in memes and other social media content that can be easily located on the internet. Paragraph 129 of defendant's second verified motion to disqualify. The court cannot be swayed by inappropriate and ridiculous outside influences. Defendant further claims, meaning the defense team claims, the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing, which has been continued due to the filing of this motion to disqualify. Right. See, all these things were supposed to happen, but the defense team said you have to rule on your own recusal before we do any of these other things. So she had to push back all of these things. So the defendant claims that the court has refused to order the state to comply with discovery rules. The court set defendant's motion to compel and motion sanctions for hearing, which has been continued due to the filing of the motion to disqualify. The previous defense motion to compel was denied without hearing as it was unsupported by evidence. Defense counsel alleges bias by the court only allowing cameras in the courtroom on one occasion. All right. The court has not allowed cameras in the Carroll Circuit Court due to its limited size and layout. The court did allow cameras in the Allen Superior Court as the hearing conducted on October 19, 2023, at the hearing on that date. The hearing was not conducted the hearing was not conducted and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in its ability of the media to cover hearings appropriately. God, whoever did that, that's horrendous, you know. The court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support a reasonable basis for questioning the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings. Defendant's second verified motion to disqualify judge and request for a finding of fact and conclusions of law upon denial of this request. If this court denies this request is denied. Let's see. Let me see if I understand that part. Defendant's second verified motion to disqualify judge and request for filings of fact and conclusions of law upon denial of this request. So it's really saying there's a comma there. So where's the other? If the court denies this request, if the court denies, this request is denied. If this court denies, this request is denied. That's a hard one to. That's like a lot of. So I know what they're saying. You know, the defendant's second verified motion to disqualify judge and request for, and so what they're. This is all referring back to what they requested. They wanted a motion to disqualify, and she needed to provide the findings and conclusions of law upon if she does deny that request. Oh, no, I guess that's where it says. If the court denies this request, and then it's denied. Anyways, she denied I think they're missing a comma in here or something. But anyways, they denied the request and will not be providing any of the facts and conclusions of law upon denial of the request. What do you mean, where am I? No, she's awesome. I mean, any of you morons out there that sent money into the Richard Allen Fund, man, you are some of the sickest, dumbest people on the planet. Just letting you know, okay? When you look in the mirror, and let's say somehow you slimeballs pay for a Slick Willie type attorney or like a witness that they could bring in, and he gets off, man, it's all on you, man. A killer free. Because Richard Allen is the bridge guy. He is the person that had them go down the hill. And he is the killer of Abby and Libby. Folks actually sent... 709 people have sent $40,220 for his defense fund. And I can't even raise $48 to make the goal on this show tonight. Come on, you guys. You can do it. Come on. We're only 44 short, for God's sakes. Yeah, funding for a child murder. I kind of want to go back up to the first part. It was kind of confusing up here. A little too technical. Defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14th regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness' refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. Right. So, I mean, they're just claiming that. Yeah, no, that's 709 wacko people. That's what I'm battling with here. So I guess we're not doing it. All right, thanks everybody. That's all I want to do is get that quick in there for the the ruling by Judge Gull. Absolutely awesome. Good for her. Don't let the slimeball defense team do all the crap that they've been doing. They're trying to get away with just absolute garbage. Brian Koberger's attorneys are exactly the same. Just nonsensical, day in, day out drivel. All right. Anyway, thanks everybody. Appreciate it, and thanks for the Karen Andrews, Paul Leonard, Lisa Valenzuela, and 655. Well, at least you gave it a shot. All right, thanks everybody. Talk to you later. Till next time. Be safe out there.
Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector, flag rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Greg is gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a spectre with a vector on his pector. With all respect, y'all, just remember I've a temple fucking check ya. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work. Alright, everybody? Talk to you later.